on matters bordering on laws and statutes, some candidates running for the highest political offices in the country have reportedly deposed in affidavit to the Independent National Electoral Commission that their academic credentials are missing. According to reports, the list of such affected political office seekers include Bola Tinubu, the presidential candidate of the All Progressives Congress, former Vice President Atiku Abubakar, the presidential standard-bearer of the People's Democratic Party, and his running mate and governor of Delta State, Senator Ifeanyi Okowa, presidential flag-bearer of Action Democratic Party, Sani Yabagi, Abdulmalik Ado Ibrahim, who will also be on the ballot as presidential candidate of the Young Progressives Congress Party, and Kabiru Masari, the placeholder for the vice presidential slot of the All Progressives Congress. We are now being joined by leading public interest lawyer, publicist, law reporter, legal commentator, author and essayist, Jiti Ogunye, for his thoughts on all of these subjects in question. Thank you very much for joining us, Jiti Ogunye. Welcome to This Day Live, the Sunday Talk.
It's my pleasure, always.
Well, quickly, let's start with
Thanks so much for inviting me.
Yes,
I'm grateful.
Let's start with the resignation of the CJN, where the CJN can resign. It can also exit by way of death. It can also exit by way of incapacitation. In this particular instance, the CJN cited its exit, cited as reason for its exit, ill health. And subsequently, the most senior member of the Supreme Court bench, Justice Ariwoola, has been appointed in an acting capacity. But the question out there is that, did the former CJN, did he voluntarily resign, or was he pushed? Or did he? What do you think? In the light of the petition, the leaked letter by 14 justices of the Supreme Court before his resignation?
Well, it is said that even the devil himself does not know the thought of man. The apparent reason that the erstwhile CJN cited for his resignation was health grounds. He said he was resigning on health grounds. However, given the events that backgrounded that dramatic resignation, because it was dramatic, the resignation took place on a Sunday, not a judicial day, not a working day. So the circumstances and events that backgrounded that resignation could suggest that the CJN was compelled by circumstances relating to those allegations to tender in his resignation ahead of his retirement age, of his attaining that retirement age. Now, in the petition or in the letter that the brother justices of the erstwhile CJN wrote to him directly, which found its way into the public domain, the CJN was accused of so many wrongs, including lack of diligence expected of the holder of the office. For example, the refusal or failure or inability of the erstwhile CJN to revise the Supreme Court rules, in spite of the fact that, as alleged by them, the draft rules had been with the CJN for about 2 years, and they didn't do anything with that. Was one such instances of indolence, administrative indolence on the bench, which could be as a result of poor health or incompetence. We can allege incompetence because before a person could attain such eminent pedestal in the judiciary, there is an assumption, there is indeed a presumption that that person was competent. So we are not going to go in that direction. But that's one of such instances. And of course, there are other allegations bordering on maladministration, conferences not being attended by the justices. They only attended two. One is Zanzibar, while the CGN attended a conference with his family members and so on and so forth. All these were alleged. The issue of welfare of the justices, including the new newly appointed, not so newly appointed now, because they've been appointed for over 6 months, 7 months or so. That was last year, if I recall, November or thereabout, who didn't have offices, who didn't have cars, and so on and so forth. So all these were there in the public domain. And indeed, a publicist for the Supreme Court for the CGN responded by rebutting the allegation, stating clearly that the CGN was supervising building of new offices, annex and extension to the Supreme Court to accommodate the new justices and all that, and that the money meant for the judiciary was not just for recurrent expenditure, but also for capital expenditure. That was it. And then, dramatically, on the Sunday, the CGN tendered its resignation. Nobody saw that coming. And that's why a number of people felt that perhaps the CGN was speaking tongue-in-cheek when he claimed that he was resigning on ground of poor health. Be that as it may, the CGN had resigned, and a new acting CGN had been appointed and immediately sworn in by the president in order to avoid a vacuum being created. And the new CGN, acting CGN, spoke following his taking of the oath that he will work for the development of the judiciary, will abide by the provision of the Constitution, and he will do all the right things and all that. And when he was pressed specifically on the letter containing those allegations, he papered over it, and he said, look, yes, it was a brotherly affair. They spoke frankly to the CGN. The Supreme Court is not divided. They are one and the same. However, which will be my parting shot, if you permit me, on that issue. Following the Senate's intervention on the matter now by saying they want to conduct an investigation, and a number of calls that have been made by civil society organizations, I think that it will do the judiciary very well for those allegations to be investigated. In other words, there should be some kind of investigation. The NJC could be the body that will order the investigation. Is so that these things are not papered over, and then an asterisk mark continue to hang over the head of the NJC and the Nigerian judiciary, because the NJC and the Nigerian judiciary must continue to enjoy the confidence of the people, eternally reposed in it. And so when allegations fly like that, and then resignation comes, and so we say, okay, after all, the person has resigned, and then we move on. We move on too often in this country, and so standards are not set. If they are set, they are not met, and if they are not being met, sanctions are not applied. Our judiciary is a body that sanctions other people. It's a body that sanctions Nigerians. It's a body that sends people to prison, and so on and so forth. It even imposes sentence of death sometimes. So that body, therefore, cannot shy away of meting out sanctions when necessary, one way or the other. And so for the records, it will be good for those allegations to be investigated, and then some kind of remedial measures are taken. Why do I so advocate? Now a new acting CGN is there. He will soon, based on conventions and traditions, perhaps become the substantive CGN. So God forbid that things were to repeat themselves. So what then happens? He then tenders his resignation and then moves on. And those allegations, and then it becomes a vicious cycle. That is not what is expected. So when things like this happen, there should be some investigation and documentation, and then the judiciary, that body, will be wiser for it moving forward. So I want to see that kind of investigation.
Yes, I mean, your advocacy for reform and all of that is in line also with the position of the Nigerian Bar Association and also other stakeholders in the matter.
Mm-hmm.
But some people are saying we should not be too optimistic, because after all, the president has given the former CJN the second highest honor in the land, the Grand Commander of the Niger, and he has also commended him, making the point that history will be kind to him and that he has made modest contributions to the development of the country and also of Nigeria's jurisprudence. And people say, look, this is quite different treatment from that of Justice Walter Kanu Samuel Onogen, who on the basis of just an accusation, an allegation by a civil society group, went through the whole gamut of being dragged on the floor and being convicted and being sanctioned and excluded from public office for a total of 10 years. Are you really optimistic that there will be any investigation, the type that you are asking for, particularly as the issues raised have to do with corruption, mismanagement of budgetary allocations?
Well, I dare hope, and in hoping, let me make this explanation. The president could have given the immediate past CJN a pat on the back. My understanding is that perhaps it's possible. I'm not prescient here. I'm not saying that that's what occurred. The CJN ought to have been given or awarded the GCON that attached to his office upon being sworn in. That was not done. So it could well be that we are looking at a quid pro quo here. You resign, so we'll give you your GCON as a parting shot. And we'll engage in all the platitudes and praise you for developing the judiciary. Move on. That could be, or that would have been the case. But the kind of investigation I'm talking about is an investigation that is conducted by the NJC. If you look at the third schedule to the Constitution, paragraph 21 of the third schedule, so paragraph E and I, the NJC has broad powers on issues, broad issues of policy and administration. It is the body that recommends the removal of any serving judicial officer, sanctions serving judicial officer, and so on and so forth. And just as it has done in the past, just as it continues to do when judges of the lower benches are concerned, including judges of the Court of Appeal, it shouldn't shy away from conducting an investigation in this regard. So the investigation I envision is not the investigation that is conducted by the executive branch of government. As a matter of fact, if the executive branch of government were to do that, it may be argued that, oh, they are interfering in the judiciary and they are undermining the independence of the judiciary. I don't think that that kind of investigation conducted by the NJC will amount to recrimination or condemnation or an overkill that this person has gone anyway. No, it's so that lessons can be learned. And I'm saying this for a number of reasons. Under the paragraph I've just mentioned, subparagraph E empowers the NJC regarding the federal judiciaries to collect, control, and disburse all monies, statutory allocations meant for the judiciary on recurrent and capital expenditure. That's why, for some time now, people have been worrying that, look, we've heard that a parting CJN receives a whopping sum of 2.5 billion as a parting shot. The question is, how did they arrive at that? Where is the template? Where are the financial regulations? I mean, how do you get to that stage? Okay? And so, while people argue that the judiciary is not being well funded, an impression is given that no, the judiciary is being funded, but there's some kind of problem at the top in the management of the funds. So when you have such worries, there should be an investigation by that body, not just to award blame, but to also see how can we prevent this kind of thing in the future, where a CJN will be so powerful, because a CJN is very powerful. He's the head of the Supreme Court, he's the head of the NJC chairman, he's the head of the Federal Judicial Service Commission, he's the chairman of the Board of Governors of NJI, National Judicial Institute, and so on and so forth. He's the #1 judicial officer in Nigeria. And so if there are no regulations, guidelines, templates, and so on, which can evolve as a result of conducting a thorough investigation, not just to condemn somebody, then we won't have learned our lessons and won't be improving on the accountability quotient of the judiciary. The judiciary should be self-accountable. Okay? So we are not just talking about the president now ordering an investigation and all that. Why the president was so eager the last time with Onogen is historical. Onogen was appointed as the acting CJN. The president was dilatory, the president was lethargic. The president perhaps had reason why he never wanted to appoint him as a substantive CJN. On that occasion, the civil society, everybody had to say, what's going on? 5 months you are not making this substantive. What's going on? And when he was eventually appointed, it was the acting president, the vice president now, acting as the acting president, that forwarded his name to the Senate. The president was out of the country on medical vacation. So that background was there, and eventually, you know, when the chicken came home to roost and all those things were done, and we had the Code of Conduct Tribunal witch hunt, you know, a CJN sent out by virtue of an ex parte order. That's what happened, that the president immediately acted upon. Yes, we knew all that, regardless of the fact that there were issues, substantive issues on that occasion with Justice Onega, which we spoke about. So the kind of investigation I'm calling for is an investigation that the NJC can conduct itself in order to ensure that the health of the NJC, the health of the Supreme Court, the health of the judiciary becomes stronger. And I think that that will not harm anybody. That's not going to be a witch hunt. Because if that is not done, then it's possible that in the future, 3 years from now, we'll come to this same issue. And then we'll make any progress. So I want us to make progress, and I really feel that that kind of investigation is important in the circumstances. That is distinct from the investigation that the executive may not want to make, and that's different from the investigation, the after-the-fact investigation that the Senate is said to be making. You know that the Senate can conduct an investigation, a kind of removal hearing, because no CJN can be removed without the 2/3 vote of the executive, of the Senate, which again was breached the last time in the Onogen's case. You know, but if what the Senate may want to do is not to result in a removal, the person involved haven't tendered his resignation. So what's going to be the effect of that investigation by the Senate? The kind of investigation I'm talking about is the investigation that the NJC is empowered to conduct. And I'm encouraging the NJC to do that so that there will be record. Okay, I get your point, Jiti Ogunye. But you yourself, you talked about remedial measures. Other people use the phrase reforms. Okay, some people say Justice Ariwoola's job is already cut out for him. How much damage has been done to the Apex Court by these latest developments, and what kind of reform would you like to see, particularly now that many lawyers are saying there's an issue with appointments to the Apex bench? Some people have advocated in the past that, look, learned men, distinguished lawyers, you know, persons who have practiced, who are interested in going all the way to the bench should be allowed to do so, even at the level of the Apex Court, not just taking people from the
Court of Appeal, and that in any case there's lopsidedness in the composition of the Supreme Court, which appears to be deliberate along ethnic and religious lines. What do you say to that?
Well, I agree that there is the need for reforms. But let me say up front that, you know, it's usually the case that beneficiaries of the status quo are usually resistant of reforms. They oppose reforms. And so what needs to happen is a kind of constructive engagement, a kind of collaboration, the bar and the bench, so that we could have these reforms. For example, the long-standing advocacy that distinguished lawyers should be appointed to the Supreme Court straight without they passing through the gamut of the judiciary, High Court, Court of Appeals, Supreme Court. That has been there for some time. But you know that judges who seek elevation from the High Court to the Court of Appeal and from the Court of Appeal to the Supreme Court have a basic expectation that they will continue to go upstairs. So when you appoint lawyers, you know, senior lawyers who may have substantial things to contribute to legal development and adjudication in the country, straight to the Supreme Court, what you'll be doing is to shut out those appellate justices, for example, who have expectation, legitimate in the circumstances, given the tradition, that they will move upstairs and they will eventually go to the Supreme Court. So fears have to be allayed. And people have to be told that we need to do this for the interest of the judiciary. And for those who are advocating from outside, it shouldn't just be that that's how they want to end their career. It shouldn't be ego-driven. It shouldn't be a matter of, oh, I've served as the president of the Nigerian Bar Association, I've seen it all, I'm a son, so the next place I want to go to now is the bench, and I'm going straight to the Supreme Court. No, it's not a matter of ego. So if that kind of injection is needed for the kind of expansion of the independent mindedness of judges, because we talked about independence of the judiciary, the question remains, how independent minded are those judges, you know, who sit on our bench? For example, there are some judges who are preponderantly elevated to the bench from the Ministry of Justice. They're working with government. They are working in the executive branch of government. And some of them stay there for about up to 10, 15, 20 years. Some of them rising to the level of Directorate of Public Prosecution, Civil Litigation in all the states. And from there, they move to the bench. The question is, how would they see things? How would they see act of the executive, which may be lawless in certain circumstances and all that? So all this will have to come into play. Now, the other issues regarding what Justice Ariwoola may do, quickly, if you ask me, I'll just name them because of time. One, the issue of remuneration of judicial officers, which has become a problem. And some people went to court recently, National Industrial Court, to litigate that issue. And the executive is dragging his feet on the matter. I think that the NJC can solve the problem. Oh yes, given what the current constitutional provisions are. If you look at paragraph 21, the power of the agency, on the issue of broad issues of policy and administration, collecting money, controlling money, disbursing money for the judiciary, under those powers, a kind of uniform salary scale for judicial officers can be put in place to cut out the executive in a very rational way to set the template for the remuneration of judicial officers. They can even add a grid to it to accommodate the inflationary trend, so that when the inflation is getting higher, so they can reflect it and all that. A grid can be attached to that, and they can do that. And I tell you that if anybody goes to court to challenge that, to say that no, the judicial officer should still be part of what level 17 they are doing in the public service, they can say no. We have the power to do that. because the Constitution allows us to deal with the issue of broad issues of policies and administration of the judiciary. And remuneration is part of administration. I know that there's a wages and wages commission and all that, but they can do this as a special salary scale. And the number of things like that can be done by the NJC under Justice Ariwoola. The issue of discipline of judges also will have to be enhanced. Before now, there's been a question of if you want a judge to be disciplined, write a petition. But recently, there are some judges that were given decisions in respect of political matters, where parties were doing forum shopping, and judges were federal high court judges and so were litigating, court of coordinate jurisdiction and concurrent jurisdiction, giving powers on the same subject matter. And they apprehended the matter. Then there was no petition. So the issue of the petition laying procedure will have to be enhanced, so that even if there are no petition, and there's an apprehension, or even a whistleblower who doesn't want to put his name to it and all that, saying that this is what is going on, then yes, you'll have some kind of procedure to apprehend that. Finally, there are some issues that are very substantive that the NJC may not be able to deal with. These issues, they are issues of judicial reforms, but they also entail constitutional reform and constitutional amendment. For example, how many justices do we have in the Supreme Court? I've stated this earlier. Our judiciary is like a cone, it's like a pyramid. The zenith, the summit is very tiny. So 17 justices, 14, sometimes 21 constitutionally allowed, are expected to determine cases flowing from the High Court to the Court of Appeal and then the Supreme Court. It doesn't happen, there is no way those justices humanly can handle such matters. So we need to unbundle the Supreme Court. And my recommendation is refederalizing our justice system, our judiciary system. Let states, or a number of states in a zone, come together, have their own Court of Appeal and Supreme Court, while we have a federal Supreme Court dealing basically with constitutional matters, as we have in the United States, so that fewer and fewer cases will go to that one Supreme Court. But what we have now is that plausibly and possibly a case can snake its way from a magistrate court up to the Supreme Court. Some people have recommended that interlocutory appeal should not be limited, and so on and so forth. If you do so, you will also be infringing on the constitutional right of appeal of parties. So I don't subscribe to that. What needs to be done is to refederalize our judiciary so that courts in state can deal with ordinary matters, murder and all that, and so on and so forth. And it will be exceptional cases of alleged breaches of constitutional provisions, right to fair hearing, for example, that will eventually go to that Supreme Court, as it is the case in the United States of America. So these are more substantive issues, but the NJC under Justice Ariwoola can deal with all the other issues that are not that substantive, which the NJC can take care of.
Ogunye, you cannot be more correct, but I'm tempted to ask you about two more questions before we move on the program. First, a very brief assessment of the tenure of Justice Ibrahim Tanko Muhammed. What kind of CJN was he? Did he really make modest contributions to the development of the law? Or under his watch, the Supreme Court went down?
Well, this is my, and I hope this is a charitable assessment. It came in when there was a crisis of confidence in the judiciary, particularly at the Apex Court, especially given the allegations that were abroad then about what the SCJN then did, which compared to the allegations we're having now, seem not to be as significant as the allegations we're dealing with right now. And so he came against that backdrop, and there were a lot of agitations and anxiety and bad will, not goodwill. But he came and he stabilized the court, and the court is able to churn out a number of decisions, some of them very worrisome, political decisions that came up in most states, a number of states, we know them, very worrisome. But he did what he had to do, and he's leaving the judiciary at this time. One way to assess, and this is my parting shot, and I feel very strongly about this, one way to assess the performance of a chief judge or a chief justice is to look at the judgments he's delivered. Not just to look at the panel he's able to constitute. And this is worrisome, even at the state level. In the past, in a number of very complicated and delicate cases that came before them, either in Lagos here, those justices of that era, Taylor, Adefara Singh, Candice Johnson, sitting in court 1, meaning the court of the CJ of that state, will take the matter and sit. The trend that we've witnessed for some time now is that chief judges don't sit any longer and deliver judgments. They see themselves as administrator general of the court, not as the adjudicator general that they should be. And so they cruise about and they say they are administering the court. They hardly sit so that they can guide their brotherly judges, because it's expected that they are the chief judges. Their judgments should be very weighty. So, relating this to what the question you've asked me, a loaded question for which I have to be very categorical. One way to assess the past CJN is to say, while he was CJN, how many panels did he presided over? How many judgments did he deliver as a sitting Chief Justice of Nigeria? You know, unlike in the United States and in other democracies, where you have the benefit of having the opinion or judgment of all the justices, in the United States, the nine of them will render judgments. And Chief Justice spoke about this in the past, about what should be done at the Supreme Court. What we have at every point in time is a minority delivering the judgment of the court. Whether 7 in constitutional cases or 5, there are a minority of 21 justices permissible under the Constitution, or 15 or 16, as the case may be, that we have in the court at any point in time. So the question then is it more than worrisome that even with that minority of 7 or 5 panels, a CJN will not sit to then give his own judgment? Of course, they are brother judges. They are on the same pedestal. They are the same Supreme Court, but he is the longest serving in the court. He is the CJN of the court. He is the head of the court. He is the leader of the court. So if we then go to check, and you don't find in 3 years or 2 years more than maybe 1 judgment or 2. So how can you then use those judgments and deliveries as a basis of assessing the performance of justices? Because performance of justices are determined not only by the administration of the court, is determined essentially by the quality of their judgment deliveries and how their judgment speak to the issue of justice. Because don't forget, our courts are not just courts of law. They are courts of justice that must do justice according to the law. So I hope I've answered your question. But
very charitable manner. Yeah, in a very charitable manner too.
I plead.
And I get the sarcasm. Anyway, just one more question, and I hope you'll be very brief with this. We have a certificate-less situation in Nigeria today with our politicians. Up to about 4 or 5 political parties, either they are presidential candidates or the running mate or whoever, they are all saying they can't find their certificates. And what the law requires, as you well know, is just school certificate or its equivalent. Now, certificates has become something that snakes and termites have, taken away. So how do we deal with this kind of situation?
Yeah.
You know, some people are talking about association of persons without certificates, you know, all over the place. Not just in the APC, also in the YPP, also in the PDP. How do we deal with that dilemma?
You know, it was Professor Olatunji Dare, a fellow eminent pen pusher like yourselves in his Guardian days, that wrote one piece then. I never forgot that piece. Called it Curiosa and Curiosa. Curiosa and Curiosa. That was during the military era.
I remember that.
Yeah. And all that. Yes, yeah, Curiosa and Curiosa. Look, our political system never stops bringing about things that are very bizarre and strange. But unfortunately, our law accommodates such bizarre development. Now, the Constitution, as you well know, requires a minimum of being able to study up to school cert level. And at the starting stage, it talks about being able to read and write. Is that basic? And so people are filling in their forms and they are saying that they can't find their school certificates and all that. The question then is, what does the law say? Section 29 of the Electoral Act, particularly Section 5 and 6, subsection 5 and 6 of Section 29, provide that if a fellow aspirant, and that implicates the issue of local standing, believes that what the candidate has submitted in his nomination forms is false, declaration of false affidavit and all that, within 14 days, he shall challenge that in court as a pre-action matter if he feels strongly about it. But even more curious that the Electoral Act then provides that if the court were to find and to rule that those declarations and sworn affidavits were false in every material particular, or in any material particular, that the court shall sanction the party by disqualifying the party and the candidate. Disqualify the party and the candidate. So if you have a party A and a candidate emerges and a fellow aspirants were to challenge the documentation of that candidate in court, that person who is challenging, the challenger, will not benefit. The party will not benefit. So another party will now be the beneficiary because that party and the candidate will have been disqualified. So there is no incentive by the law to encourage even a fellow aspirant to come forward, not to talk of the provision of the law, excluding outsiders. Because I've seen a lot of people, civil society people, lawyers, say, we are going to challenge this. The law does not give them the pedestal to challenge anything. I think it's just for the media noise and all that. That's what the law is saying right now. And so, for me, it then becomes a matter of integrity. Whether the voting public will believe a particular candidate or not. Because the issue here is that we all know these candidates are studied well beyond school certificate level. We know that. We know that. But for some strange reasons, maybe some of them personal, some of them as a result of misplacement, they may so think, this kind of thing happen. I must say, though, that in my own case, for example, I never obtained my school certificate. We had statement of result. We used that on the letterhead of the Victory College, the school I attended, and then it was the basis of my securing admission at the university admission office interfaced with WAEC to confirm the result, and that was it. I never had any reason to go back to my secondary school to obtain that certificate. I understand that at a particular time, they will then return the certificate to WAEC. So I don't know whether this is what has happened to some of the candidates, but it's very strange that a great number of the candidates uniformly are returning with, I've lost my secondary school and primary school certificate affidavit and all that. So that's what I can say about that.
Okay, on that note, I would like to thank you very much, Jiti Ogunye, for joining us today on This Day Live, the Sunday Talk Show. Thank you very much indeed.